All right, good afternoon, everyone. Welcome and thank you for joining us today. My name is Grace Spulak and I am the director of the New Mexico Commission on Access to Justice. And we are so happy to be here today with Kate Thomson, who is with Rothstein Donatelli and who is going to talk with us about expungement for this webinar. And this is a topic we know there's a lot of interest in. There's a lot of need for expungement and help with expungement in our communities. And so we are so thrilled that we are finally able to get this webinar out for you today. Before I introduce Kate and turn it over to her, I just want to go through a couple of housekeeping things. So as we are going through the webinar, you can put questions in the Q&A box and also in the chat. I will be monitoring both of those things. So I'll be on the lookout for questions as Kate is talking. If you would prefer to speak your question, you should have a raise hand option at the bottom of your screen too. You can raise your hand and I will unmute you so you can ask your question verbally if you would like to do that. We're recording this webinar and we will send the link to the recording around afterward with the materials. So you'll have those for reference if you want to go back and look at something. And again, just thank you all so much for being here today. And thank you so much, Kate. Kate Thomson was born and raised in New Mexico and got her bachelor's degree in political science and English from the University of New Mexico, and also attended law school at the University of New Mexico School of Law, where she found a passion for constitutional rights and client advocacy. After law school, Kate worked with the law offices of the public defender for 3 years. And in 2017, joined Rothstein Donatelli as an associate attorney, where she expanded her practice from criminal defense to include civil rights, litigation, jail reform, and expungement. And with that, I will turn it over to Kate.
Thank you, Grace. Thanks for having me on here. Expungement is one of my favorite law topics to talk about because it's one of the things I really feel very passionate about, and I really enjoy working on these cases for my clients because expungement can be it's really a positive thing. A lot of the cases I do civil rights cases and criminal defense, and a lot of my work can be, kind of sad stuff and everything. But this is one of those things where I can really advocate for something that can be a very positive change in my client's life. So I'm glad to be here. And, I'm an attorney at Rothstein Donatelli law firm. And at the end of the presentation, there'll be my contact information. So if you have any questions, please feel free to reach out by phone or email to chat about expungement. So today I'm going to be walking you all through how expungement works, how to find out if somebody's eligible for expungement, and then how to put together a petition and all the steps that come after that. All right. So the first thing to talk about is, what is expungement? So New Mexico did not have an expungement statute until a couple of years ago. We're actually one of the last states to enact an expungement statute, but luckily ours is one of the broadest in the United States. So the Criminal Record Expungement Act is 293A1. And expungement under the statute means removal from access to the general public of arrest records, the pleadings like the complaint, indictment, anything that comes after that, plea of guilty, conviction, acquittals, dismissals, basically records that are publicly accessible. They are removed from access to the general public. So that means expungement is essentially akin to sealing of the records. They aren't actually destroyed, but for the purposes of background checks or looking somebody up on New Mexico case lookup, those records will no longer appear once they have been expunged. So under the expungement statute, if an expungement is granted, the proceedings shall be treated as if they never occurred. So the New Mexico Department of Public Safety, the district attorney, if they get an inquiry as to, a particular person or about the case, and these records have been expunged, they can reply to an inquiry that no record exists with respect to that person. And so why bother going through that? A criminal record, as you all are very likely aware, can affect job applications, housing applications, and sometimes just somebody's reputation. I've certainly had clients who wanted to get their record expunged just because they were embarrassed to have that on their record. They don't like it when somebody looks them up, it's available. So it can be, really important for somebody to move on with their life when they have, really they've done their sentence or the case has been dismissed and they just want to move on and no longer suffer those collateral consequences.
Kate, we have a question about how expungement intersects with immigration proceedings, and how is an expungement treated for immigration purposes?
So I am not an expert at all in immigration law. I can tell you I have had clients who have come to me about expungement, and I've had them talk to an immigration attorney who has advised them that it is the expungement isn't necessarily helpful because they need to have access to the records for certain applications. I don't know, either for citizenship or, some kind of visa or something. And that what would be better for them is to try to get, if they had a plea, to go through the process of trying to withdraw the plea, such as if they were not adequately advised as to the consequences of the conviction. So I would, if you have somebody who's looking for expungement, for immigration purposes, I would advise talk to an immigration attorney because expungement might not be in their best interest. But again, not my area of expertise. Okay, so the laws, I already mentioned the Criminal Record Expungement Act, but there's also rules now. The Supreme Court has just come out with approved rules for expungement. They went into effect for any cases pending or will be filed on or after January 28th. So just in the last week, basically, these have gone into effect. So we have a new rule, which is 1-077.1. That's the expungement rule. It would be really helpful. It's in the handouts. That's what you're going to need to look at. Also, you need to know the expungement statute, 29(3)(a)(1) et sec. So there's different sections for the different categories of expungement. And then also all the expungement forms, their use are mandatory, and we've got the numbers listed there. And then there have been some amendments to the process and limits on public access rules. There's just some tweaks to those to reflect issues particular to expungement. And one thing to note is there are some differences between the statute and the new rule, such as certain timelines. And so in those cases, the rule controls. So make sure you're looking at both, but really, keep in mind the rule. And there are notes about the differences in the committee commentary, on that rule. So the first step, if you're going to help somebody go through with an expungement petition, is to determine whether they're actually eligible for expungement. And so you first identify what category of charges their prior case would fall under. So there's about basically 4 different categories for expungement that have different eligibility requirements. So First one would be identity theft. So if somebody wants to get a case expunged because they were wrongfully identified, and then as a result of being a victim of identity theft. There's non-convictions, convictions, and then there's the newest category is what I'm calling automatic expungement. And we'll talk about that later, but that relates to cases that are eligible for automatic expungement under the new Cannabis Regulation Act.
And so, Kate, there's another question related to immigration, but I think also kind of in terms of eligibility more broadly. And so the question is basically whether this law applies to immigrants who are convicted in municipal or magistrate courts.
Okay, so whether the expungement law applies?
I believe so, yes.
Okay. So there's nothing in the expungement statute that differentiates between people who are citizens or not. A person very well could be an immigrant and be eligible for expungement, but I don't know if necessarily going through the expungement process would be helpful to them. And I really would just got to talk to an immigration attorney who would be able to answer that question. Okay. So, the first thing that I do if I have a client and I want to find out if they're eligible for expungement is I pull their criminal record up on, Odyssey or New Mexico case lookup. I prefer Odyssey because then I can pull the pleadings and look as well. Sometimes cases are so old that you can't really tell just looking the case up online, and you have to request the pleadings. So the pleadings you're going to want to look at are going to be like the criminal complaint and then how the case was disposed of, because the two things you really need to know are what the offense is and what the final disposition was. So whether it was dismissed, whether they pled guilty, whether they were convicted, if they did plea or were convicted, did they get a conditional discharge? Did they go through and do like a pre-adjudication diversion program and it was dismissed? Did they get a deferred sentence? You want to be able to answer for yourself what happened with that offense.
And so another question just on getting records and eligibility. So should folks also look for any municipal court records? So things that wouldn't be in Odyssey, so wouldn't necessarily show up in SOPA or on the kind of the New Mexico courts online lookup.
Right. Yeah. If you can't find it by looking it up online, you can just request the records right from the court. And each court, is going to have a different way of requesting the records, but that's what I recommend you ask for is whatever that initial charging document is. So if it was a citation or complaint or criminal information, anything like that, you want a copy of that so you know what the charges were, and then you want whatever records there are of the disposition of the case. And sometimes you need to dig past the actual like sentencing, because somebody may have gotten a conditional discharge and then it might have been revoked later, or they might have gone through a conditional discharge but then a dismissal was never actually entered. So you want to find out everything that happened when the case was disposed of, and so you can just request all of that, or you can go to the court and look at the file. That you can do that too generally. Okay, and so what I was just talking about. So what you're looking for, what is the offense? What's the disposition? You also want to know the date of the final disposition of the case. And then if they have any other convictions, you also want to know about those as well, because for convictions, there's a specific waiting period for being eligible for expungement. And that waiting period starts at the end of the sentence for any criminal case, any criminal conviction. So you need to know the timeline for all of their criminal record, not just what you are looking for expungement. Because for instance, one case might be eligible for expungement and one might not be. And so you might not necessarily feel like you're concerned with the other case. But if that one happened after the case you're trying to expunge, you need to know when they were done with that sentence, because that will affect their eligibility as well. So basically, you need to know, basically make yourself, if they have more than one case, make yourself a timeline of the case, the dispositions, and when they actually finish their sentence. Okay. So I'm going to go into talking about the specific types of expungement. I'm going to focus mainly on non-convictions and convictions because that's what you're going to run into the most. But I'll talk about the other ones briefly as well. So identity theft, it's pretty straightforward. If it resulted in the victim being wrongfully identified in arrest or public records, they're eligible for expungement. They don't have to wait any period of time, and it doesn't matter what the offense was. You're going to need to include documentation demonstrating that they were a victim of identity theft, but otherwise, there's not any of these other specific eligibility requirements like a waiting period. So non-convictions. So non-convictions is actually a pretty broad category because it doesn't just include somebody where their case was dismissed or they were found not guilty. So non-convictions, it's defined as people charged with any offense that was disposed of without a conviction. So the statute includes acquittals, findings of not guilty, of course, no lays, no bills, or any other dismissals. So the state files a nolle prosequi or they file a dismissal, that is all included. Also included is any kind of pre-prosecution, pre-adjudication diversion program. So say somebody goes to Metro Court and they do the early intervention program, they do that for 6 months, and then the case gets dismissed. They've never entered a plea of guilty or anything like that. They just go to this diversion program, gets dismissed. They fall under this category. Also includes conditional discharge orders. So they get a conditional discharge, they fulfill their obligations, and it gets dismissed on a conditional discharge. That is also included as a non-conviction. The expungement statute was amended last year to include penalty assessments under the criminal code as a non-conviction, as well as deferred sentences under the motor vehicle code. Before those changes, it was not super clear about traffic offenses. So this clarifies that, though it also arguably the deferred sentences under the motor vehicle code may include DWIs with a deferred sentence. So typically, if somebody gets a DWI and it's their first DWI, the sentence, if they plea, is typically they get a deferred sentence with a requirement to do the first offender program. And then once they've completed that, the case gets dismissed on a deferred sentence. For any of you who are unfamiliar with criminal law, sentences can be deferred, suspended, or it can be, jail, basically. And so a suspended sentence is where a sentence is imposed and then it's suspended on conditions like doing probation for a certain number of years. A deferred is a little bit different because the sentence is, they enter a plea of guilty, but the sentence is deferred and on the condition that they, fulfill, say, a year of probation, and then they're entitled to a dismissal after that. It's deferred sentences are typically considered convictions regardless of the dismissal. However, because this expungement statute specifies deferred sentences under the motor vehicle code, that arguably includes DWIs. I do not know anybody that has tried it yet. And I have not had the opportunity to try this yet for expungement. And the reason why this is a gray area is that DWIs are one of the exceptions to convictions that are eligible for expungement. So it may include DWIs with a deferred sentence. Without that deferred sentence, a DWI would not be eligible. So non-conviction offenses are eligible after 1 year if no other charges are currently pending. So if somebody is charged with a crime, it gets dismissed. It's been 1 year since then. As long as they don't have any other criminal cases pending, they're eligible to petition for expungement. Non-convictions include any offense. So somebody is charged with murder, gets dismissed. A year later, they can expunge it. There's really no exception as long as it's considered a non-conviction. Okay, so convictions. So some offenses are not eligible if they are conviction. So those include any offenses committed against a child, offenses that cause great bodily harm or death to another person, sex offenses that are defined in the SORNA statute, embezzlement under this specific statute, and DWIs, like I was just mentioning. So if it's a conviction for any one of those offenses, then they cannot get it expunged. So I want to point out kind of an area to be mindful of. So the statute doesn't actually list some of those offenses by statute number. So the ones like embezzlement, are really straightforward. You look at your offense and see, is it this particular statute number? If so, it's not eligible. But offenses committed against a child and offenses that cause great bodily harm or death to another person, those are not specified by a particular statute number. So you have to actually look at what the person was convicted of and what was in the complaint. So a district attorney could argue, if they pled guilty to aggravated battery with a deadly weapon, but the criminal complaint says that great bodily harm resulted, say it was, from a stabbing or something like that, or they were convicted of a simple battery, but the victim was a minor, they could argue that that offense is not eligible for expungement under this statute. So again, it's important when you're pulling together the pleadings for an expungement petition, make sure you have that initial charging document so you can see what the underlying facts were, in addition to what the offense was that they actually ended up being convicted of. And I would certainly argue that expungement should depend on the actual elements of the offense that they were convicted of, rather than what was in the initial charging document. And if there really is a dispute about this, one thing you can do is try to pull either the recording or transcript from the plea hearing, if it was a plea, so you can see what the factual basis for the plea was. Whenever somebody, pleads guilty to an offense, either the defense or the prosecution needs to lay a factual basis. And so there will be something in the hearing where they say, on or about this date, this defendant did X, Y, and Z. And so those are the factual basis being laid for the elements of that offense. So you can look at that and see, oh, there wasn't anything about great bodily harm, or there wasn't anything about the victim being a minor or something like that, and use that to argue that that offense is eligible for expungement. And then in addition to just showing that eligibility, that the offense is actually eligible, you have to show the courts that the expungement serves the interests of justice, that the petitioner has completed their sentence and paid all fines and fees. That includes any victim restitution that was ordered. and that they have also met the requisite waiting period without any other conviction. So waiting periods are measured from the last date of serving a sentence for any conviction in any jurisdiction. So basically, if somebody has multiple cases, you need to look at when they were completely done serving a sentence for their last conviction. So, you know, if they have 3 cases, you look at the most recent one and look at when they've finished that sentence and measure from that point and see, okay, how long has it been that they have not had any other conviction? And so what the waiting period is depends on the charge that you're trying to expunge. So for any misdemeanor or municipal ordinance violation, the waiting period is 2 years. 4th degree felony or a misdemeanor aggravated battery, it's 4 years. 3rd degree felony is 6 years, 2nd degree felony, 8 years, and then a 1st degree felony or any offense committed under the Crimes Against Household Members Act, it's 10 years. So, you know, if you look at, you know, the criminal record and you say, oh, aggravated battery against a household member or just battery against a household member, that's a misdemeanor, you know, it's actually 10 years, not 2 years, because it was committed under the Household Crimes Against Household Members Act. So it's just something to be mindful of. Okay, so automatic expungement. So I mentioned briefly before, so the Criminal Record Expungement Act was amended last year. In addition to those little tweaks about penalty assessments in the Motor Vehicle Code, it was also amended in tandem with the Cannabis Regulation Act. And what it did was offenses that are now legally invalid under the Cannabis Regulation Act are now eligible for automatic expungement. So if something is legal now that wasn't legal before due to the Cannabis Regulation Act, they are eligible for automatic expungement. And so that is basically the automatic expungement. You shouldn't have to do anything, but you can. You can still file. The 2 years after the date of conviction or arrest, if the offense is no longer a crime under the Cannabis Regulation Act, there should be automatic expungement. Basically, the Department of Public Safety is going to go through a process where they pull these records, and they're supposed to do it by a certain date. Basically, there's a whole bunch of stuff about that I'm not going to get into with the deadlines and stuff. And it should go through an automatic expungement process. If there's multiple offenses, you know, say there's, you know, possession of marijuana along with, I don't know, some other charge, resisting arrest or something, only the charge that's now legally invalid will get expunged automatically. The new rules for expungement, the 1-077.1 talks about how if they are eligible, but the case has not been expunged yet automatically, you can still file a petition and they won't require a filing fee. So that's handy. You can just go ahead and proceed with the expungement petition without waiting for the automatic expungement process to go through. Okay. So that was the first step of figuring out you know, whether you can proceed with trying to petition for expungement. And I'm now going to talk about how you actually do the expungement petition and what happens after that. So very handily, we have forms for the expungement petition, and they're mandatory. So you have to follow, you know, the forms when you are doing your expungement petition. And there are 4 different forms for those 4 different categories of expungement. And I've listed them out here so you can see what number you need to look at. And those are also in the handouts as well. So I'm just going to talk about the non-conviction and conviction ones again, because those are the most likely ones you're going to come across. So the non-conviction petition, the support, you need to provide, in addition to filling out the petition itself, the form, you have to provide some supporting documentation. So first you need to include the record detailing the offenses. So the docket sheet, the criminal complaint, and then documentation showing the final disposition of the offense. So a copy of the dismissal, a copy of the judgment and sentence, or, you know, if it was a conditional discharge, the order dismissing it on the conditional discharge, just something that shows how the case ended. And then additionally, you need to get the client's record of arrest and prosecution, or rap sheet, from the Department of Public Safety. And that needs to be dated no later than 90 days prior to filing. So one of the things you're going to want to do right away is go ahead and request that from DPS. Basically, it's a form that your client signs, gets notarized, submit to DPS, and you get that back. Usually takes 4 to 6 weeks to get the rap sheet back. And so you want to make sure to keep an eye on your timeline so that the rap sheet doesn't, become stale. So later than 90 days. So you want to, once you get that, you need to file within 90 days. The purpose of including the rap sheet is to show the court that the petitioner doesn't have any other offenses pending, because that's one of the eligibility requirements. For a conviction petition, there's a little bit more that you need to include. So you need to include both an FBI background check and the Department of Public Safety background check, or rap sheets. Basically the same thing, dated no later than 90 days prior to filing. So the FBI background check can be obtained through, they have to get fingerprinted, and they can either get the fingerprint cards, and you can submit them, by mail to the FBI to get the background check back, or they can go get an electronic fingerprinting done, which is more expensive, but you get the background check back right away. It's not available everywhere, but say they're in Albuquerque, that's something that they can get done here. And so you get, if they do the electronic one, you get a PDF background check back within 24 hours. Otherwise, the FBI background check takes probably about as long as the Department of Public Safety background check. So just keep that in mind about when you want to request those. Consider, you get the FBI done right away, and then it takes about a month to get the DPS one back. So you want to make sure that you're requesting these in a time that neither one of them becomes stale before you're ready to file. Is there a question?
Yeah, we have a couple questions. So the first, what if a victim admits to embezzlement, but at the time of the crime was suffering domestic abuse and mentally was not fully aware of what they were doing? Is there any way to get around that restriction in the statute?
No, there isn't really any wiggle room on the convictions. If they were, if there was some issue with, the plea they entered into, they can try to withdraw that plea. If they didn't fully understand the consequences of the plea agreement, or there was something, some kind of, issue with they didn't get adequate, representation by their attorney, or some other kind of constitutional issue with the plea agreement they entered into, they could try to withdraw that plea. But there's really no wiggle room in the statute for offenses that are not eligible. It's just, if they have a conviction for one of those particular offenses, it's not eligible for expungement.
Thanks. And then one more. So many times on conditional discharge, the person doesn't come back to request a dismissal after fulfilling the deferred sentence.
Mhm.
They need a final dismissal to request expungement.
Right. And that's definitely something we've done is we have just, what we will do is we file basically a motion for the dismissal, and then we will do the expungement after. We usually file a motion asking for a dismissal effective as of the date that they were eligible for that dismissal. And the Latin term is escaping me right now, but it's a motion for, oh, now I can't remember it. But basically you're asking for, the dismissal effective as of that date, so that you don't end up in the situation where the dismissal is, say on the conditional discharge is, you don't have to wait an entire year from that. So you want the order to say, this is dismissed as of, that date, however many years ago. And just one other thing to point out, sorry about, back to the question before, is if there is an instance where somebody got a conviction that wouldn't generally be eligible for expungement, but it's because they were a victim of human trafficking, there's another statute for sealing records for human trafficking victims, but that's not it's not under the expungement statute, but it has a similar effect of sealing the records. But yeah. Okay. Are there additional questions? Because I feel like I see a lot of numbers.
So there's, yeah, so nunc pro tunc, that's, someone made that. That's
Nunc pro tunc, yes.
That
That's
was
what it is.
coming to me, and then I
Thank
was
you.
like, I haven't done this for so long.
Yes,
I could just.
that's what it is. You want a motion for a nunc pro tunc dismissal? Yeah, that's what you, thank you.
Yeah, and then also a comment, there's also instances where the FBI criminal background check shows something different than the state DPS
Mhm.
rap sheet or vice versa. Some crimes don't show up.
Yeah, that happens. I've certainly had cases where there's an inconsistency in those, and it's, I'm not sure why, but it is good to have those and review them, before filing, so you can see what they say and what you're submitting to the court. But yeah, sometimes the FBI one just won't show some, New Mexico cases, especially if they're sort of minor things. And so one of the, I'll talk about it in a minute, but one of the things is if you submit a non-conviction petition and there's an objection to it because of something that's contained in the FBI background check, then the objecting party needs to provide you a copy of that. So then you can see that if there's something in the FBI background check that's problematic. Okay, so yes, so you need both the FBI one and the DPS background check for a conviction petition. You need that documentation showing that they completed their sentences for the convictions you're trying to expunge. And then you need documentation showing the completion of any other sentences. I think it's helpful to include basically the docket sheet. And by docket sheet, I mean, you go onto Odyssey, you look up the case, and then it shows you the case history. So, when they were arraigned, what happened after that, all the subsequent hearings, because that way you can show, okay, they, there wasn't any subsequent amendment to their sentence, or they weren't revoked and from probation and given, another thing. Basically, it shows the whole case history so they can see when the case was done. So that's helpful, along with their judgment and sentence, any prior modification to their sentence. So say, they ended up with, 5 years of probation, but, they ended up just getting revoked in order to serve 100 days in jail, and then everything else, and then they were done, or something like that. Who knows? Basically, you want to make sure that what the sentence that was served was and when it was done. And you want that for any other sentences they may have served as well. And then documentation showing final payment of any fines and fees or victim restitution. I find that hard to find, but if they haven't been revoked for, while they were on probation, or there wasn't any like violations for not paying fines and fees or not paying victim restitution, then you can show that by showing that there weren't, any violations of their sentence. So if they weren't, if they were ordered to pay fines and fees, but the Odyssey printout shows that they owed $0, there you go, there's proof. Or they were ordered to pay victim restitution, but they finished their sentence and it shows that there weren't any, violations of their sentence for not paying victim restitution. That shows you they must have paid it, because they weren't violated for it. Some of these cases are so old, or even not that old, but your client's not necessarily going to have the receipt from paying victim restitution. So that's how I have done it in my expungement petitions, is showing like, look, they finished their sentence without, any revocation, any violations for not having paid this. Therefore, the final date of, they paid their fines and fees and stuff by or before the date that they finished their sentence. It's not always perfect, but it's, in my experience has been enough. Okay. And then the, sorry, there's a question.
Yes. So do you see people successfully doing these pro se?
That is a hard question to answer, because a lot of them were under seal or filed under seal or then sealed once they've been completed. So once an expungement proceeding is done, there's no records of it. So I would have no way of knowing. I have had one person come to me after they tried to do it pro se and then it got rejected. And so I helped them do it. But I think that it's possible for people to do these pro se, depending on how complicated their criminal history was. Some of these are very straightforward. It's like one case, it got dismissed, it was over a year ago, easy to fill out your form, submit everything you need, there you go. I had one guy who had multiple convictions staggered over different times. There was overlaps in sentences. Once, like he had one case where he was sentenced and then he got another case, and then that case was combined with that case, and the first case was already joined with another case. So he ended up with like 3 cases in one. It was just a nightmare. It took me hours to sort through his record. I cannot imagine somebody would have been able to do that pro se. So it really depends. So I think it's possible, but I also think it depends on somebody's ability to sort through these rules and follow the direction of, the expungement rules. So, yeah. So like all good law school answers, it depends. Okay. So demonstrating justice will be served by an order to expunge. So this is where we don't have as much of a straightforward, are they eligible or not, kind of analysis. So there are factors, however, in the expungement statute that a judge is supposed to review in order to determine whether the expungement would serve justice. So nature and gravity of the offense or conduct is something to consider. It's going to be a lot easier to expunge a conviction for a misdemeanor than, a 3rd-degree felony. Petitioner's age, criminal history, employment history. So do they have a whole lot of convictions on their record? Are they, what have they done since this record? So have they, since they served their sentence, have they gone and gotten a job, or, or gone to school, or, stuff like that. Length of time since the offense and completion of sentence. So that's another one too. So, was this a conviction from 20 years ago? I've had clients where we've petitioned to expunge offenses from 20 years ago or longer. And that certainly weighs in their favor. Though sometimes, even if it was recent, it's not necessarily going to preclude them from getting their expungement petition, granted. But it's one of the factors that they're going to look at. Adverse consequences if the petition is denied. So, in some cases, somebody will have had issues getting housing or a job. And then that's something you want to include in the petition, saying like, look, if you don't grant this, they're going to continue to have these problems of being denied housing applications or not getting jobs, or say somebody is looking for, they're about to graduate school and are just going to start applying for jobs, and very likely this conviction could be an obstacle for them in this new career path. Those are all kind of different arguments I've had in my prior cases, and things to think about. Is this going to require a conversation with your client to figure out what kind of things to put in the petition? And generally, what I've done in my petitions is put in like a paragraph or two, depending on the petition and what kind of information I've gotten. But basically in the petition itself, kind of laying this out of like, look, for example, like, look, this was 10 years ago. At the time, the petitioner, was suffering from like substance abuse or, something else, or got involved with like bad people and ended up in this bad situation. But since then they, completed their sentence and, went to school and graduated and is now, employed doing this, or they're trying to seek employment, something like that. You can kind of put all that in. And then what I also do as a supporting documentation for that is get, if they have, like a degree from, school that they've gotten, or like a journeyman's work certificate that they've gotten since the conviction. I like to get supporting letters from people. That's typically the main thing that I include. And so, from family or friends, or sometimes I've even had, clients, employers write letters in support for them. Basically, what you want to show the judge is that, look, they're not the same person that they were when they got this conviction. This is how they've turned their life around. And why they don't deserve to continue to suffer the collateral consequences of this being on their record. You want to show that they're not going to be the kind of person that's going to do this again, that, it's anything that you can think of that, helps to show that, is really helpful for the judges to look at. And then the judge is also going to consider any objections filed by the district attorney when they are, considering this justice piece.
So a question on kind of the process overall. So can an expungement petition cover multiple offenses, assuming they're all eligible for expungement, or do you need to submit a separate petition for each offense?
I am going to get to that, but yes, as long as it's in the same jurisdiction, you can submit one petition for multiple offenses and cases.
And then another question, kind of on how frequently are district attorneys, or at least are you seeing district attorneys object in these cases?
I have personally not ever received an objection from a district attorney. Another attorney I have, talked to about expungements, one of my colleagues in the legal community. He has had a couple of objections. One was an argument about whether a deferred sentence counted as a conviction or a non-conviction. And then the other issue he got an objection on was one of those issues of whether something counted as a believe he got an objection on whether something counted as a great bodily harm offense, because it wasn't what the underlying, what he actually pled to. I think it was either like a simple battery or deadly weapon or something like that. But because the complaint itself had alleged great bodily harm, he drew an objection from the district attorney. And I don't remember what the outcome of that one was. But yeah, typically I have not really seen much in the way of objections.
Okay, thanks. And we have a couple more questions.
Sure.
And so I don't know if this is a good place or if we should, we're almost at the top of the hour, so I want to make sure you have time to get through your material. And then we can do some of the additional questions as well. So I guess what is your preference on that?
Why don't I get through some more? I don't think I have a huge amount more, but I want to make sure I get to some of this stuff, and then we can do all the questions at the end.
Perfect.
Okay. Okay. And to answer one of the questions that was previously asked, yes, a petition to expunge can contain a request to expunge multiple records of arrests or criminal charges, as long as they were in the single judicial district. So you can't do one from Santa Fe and Albuquerque in the same one. It would have to be anything in the second judicial district, for example. So where you file in the district court of the county where the charges originated, the arrest occurred, or in which the conviction was entered. So the case is out of Albuquerque. It's filed in the second judicial district court. So non-conviction expungement petitions are filed under seal. And that's a requirement that only applies to non-conviction expungement petitions. And then once you file the petition, you have to serve it, and who you serve it on is going to depend on whether it's a non-conviction petition or a conviction petition. So, excuse the cafe. So a non-conviction petition gets served on the district attorney and the Department of Public Safety. And for convictions, it's those two plus the law enforcement agency that arrested the petitioner. If you're trying to figure out who the law enforcement agency is, look at the criminal complaint. That will usually tell you who it is. Sometimes you can find that out from the background check as well. And then you need to file a certificate of service, and there's forms for that as well. And the rules stipulate how you serve it. It's by US, I think, certified mail, but look at the rules. So I'm trying to go through this a little bit quickly so I can answer your questions. Okay, so once you filed your petition and filed the certificate of service, the rules say that there's 60 days for any objections to be filed. So the agencies entitled to notice must file either specific objections or a notice of non-objection. And if they file a notice of non-objection, then they are excused from any further participation. So they don't have to come to a hearing. They don't have to do anything. They're done. And I mentioned before, if they do object based on what's contained in the FBI background check, then they have to provide a copy of that to the petitioner for free. And then once the 60 days has passed, so once you get your petition filed and served, you need to calendar the 60 days because you're required to file a notice of completion of briefing, and you have to serve it on any parties who filed an objection. And you must attach an affirmation in support of expungement. And that is signed by the petitioner. So basically that form, and if you'll see it when you get the handouts and look at it, it's basically saying, I still don't have any new charges pending, or yes, there are new charges pending. And so you fill it out according to what's true, and the petitioner signs it. And so if they did happen to pick up a new charge, then the parties can have 20 more days to file any objections. So typically, and hopefully, you're just signing an affirmation that says there's no pending charges, and you attach that to your notice of completion of briefing. And that helps signal to the court that case is ready for decision, which is great because sometimes the courts sit on them for a while. So I'm pretty pleased that that's now in the rule. So sometimes you're going to have a hearing on the expungement petition. It would be after the filing and service of the notice of completion of briefing. It's not, a hearing is not required for any petitions other than one for a conviction, unless there have been objections. So if you file a petition for a non-conviction expungement, then if the DA's office, for example, files an objection, then you're going to have a hearing. If it's a conviction, then you're definitely going to have a hearing. In the forms for the petition, there's like a checkbox for providing notice to the court if you want it to be telephonic or virtual hearing. So you can check that off unless you really want it to be in person. The burden is on the petitioner to, for the expungement petition. Be prepared to address any objections that were filed. And you would know if there were any. And we talked about that these conviction petitions require establishing that justice will be served by the expungement. I typically have my client testify, and I prepare them for that. I also may have witness testimony, sort of depending on how strong of a petition I feel like we have. And usually it's pretty short. Sometimes it'll just be, one or two people that actually did letters in support, or someone in addition, basically talking about, how well they know the petitioner, what they're like, are they law abiding, here's all the great stuff about them, what a great person they are, et cetera, kind of anything that goes to what your arguments were for why expungements in the interest of justice. So, look at those factors when you're laying out your argument and getting witness testimony. So those factors are in 29.3A.5E. And then after the hearing, the judge has to issue an order within 60 days. That's been my experience. The order usually comes out within a day or a week. And then if it's granted, yay, the agencies have a minimum of 60 days to complete the expungement. The expungement proceeding itself also gets expunged. And then the court causes a copy of the order on the petition to be delivered to the relevant law enforcement agencies and courts. So you don't have to send out the orders to, everyone. They should get it from the court itself. So that's helpful and less work for you. I highly recommend checking to make sure that the expungement order actually went through. So you don't necessarily have to like run their background check again or anything, but at least looking up on Odyssey or New Mexico case lookup to make sure that the cases have been taken down. Sometimes the underlying criminal case is gone, but the expungement case is still there, or the expungement case is gone, but the underlying criminal case is still there. And sometimes it just has to do with the information didn't get to the court, especially if it's the district court expunging, like a magistrate court's case doesn't always make it to the clerk. So just following up and making sure that it actually went into effect. So the order is going to prohibit all relevant law enforcement agencies and courts from releasing the copies of records to any persons except as authorized by the Criminal Records Expungement Act or on order of the court. So there's small exceptions there's like an exception for if they're like applying for like the Securities and Exchange Commission or something like that, really sort of minute exceptions. Okay, and that's it. All right. So questions.
All right. Awesome. So the first question, other than Supreme Court forms, are there any resources we can point pro se litigants toward to help them with this process?
So the court's website, I think the New Mexico court's website, and I know the Second Judicial had a kind of expungement packet that included some step-by-step guidelines. I don't know if they have changed and been updated since the new rules went into effect, but there were some prior to that. I would hope that they would update them now that, but I don't know if that's actually gone through yet. So you can check the websites for that, but they had some, the Second Judicial had like, it's, generally a guide to expungement and some step-by-step for non-convictions and convictions, and I think identity theft as well, with some templates as in addition to that. But again, I don't know that they're up to date right now.
And so Asia Brooks from the Second just let us know that they're updating their website, and we'll hopefully have them updated by Friday. So thanks, Asia.
Oh, that's great. I'm glad to hear it.
And so the next question, this is a district court process, and what do you think limited jurisdiction judges need to know about the process? So metro magistrate, municipal judges.
Like about getting things expunged or after it's been expunged? I'm not really sure.
I guess just generally, I don't know, Laura, if you want to clarify your question at all.
I mean, because it is a process that goes through the district court. It's a civil petition. It's decided by the civil judges in the district courts. And then the orders, once it's granted, go to the clerks for the courts where they originated out of. So if it was a magistrate, muni, or metro court case, those clerks would get the orders. And so basically should follow the order that those records should be sealed and not for release unless it meets one of the exceptions of the expungement statute. I don't know if there's further questions on that.
I don't see anything right now. The next question, and I think these next two you answered, but just to be sure. So after expungement is successful, what are the consequences of answering no to felony convictions on things like employment applications, professional licenses, security clearances?
Well, I'm not a security clearance expert at all, but generally speaking, here's how the expungement statute's not entirely clear, because what it says is anybody who's asked about these records can say no records exist. And the whole point of the expungement statute is for people to be able to overcome those obstacles to, getting jobs. If you still have to answer yes, even though it's been expunged, what's the point? So I would hope that you could answer that no, but it doesn't actually say, and I would be very careful on things like security clearance type upper level applications, and those, answering those kind of questions, because that's like kind of a whole other thing. So I don't have a great answer for that, but I think that the whole point is that you're able to get through those applications without your criminal record barring you from proceeding on those, because that's the whole point of the statute. But the statute doesn't say, and neither do the orders say, that you can deny that record, that case happened, or that you had a conviction, because it doesn't change the fact that it doesn't, it's not like a pardon. It seals the records.
Thanks. And so next question, if the conviction was in municipal court, would the district court weigh in on a municipal court matter? Also, would that petition to expunge a municipal court case show up on nmcourts.gov when it doesn't appear, the municipal case doesn't appear on the court website?
Um, okay, what was the first part of the question again?
So basically, if it's in municipal court,
Mhm.
does the district court weigh in on that? Basically, do you go to district court to expunge it?
Yes, yes, that's right. Yeah, the district court can expunge the records in any like that came out of the district court or the lower courts. That's where you file it. There is a bit of an issue with if it was appealed, which I've come up with recently, that you may have to go, if it was like appealed to the Court of Appeals, the district court isn't necessarily going to order the Court of Appeals to do anything. So you may have to go through a second step of filing a motion to seal appeals records. But yeah, the district court will order the magistrate, muni, or metro courts to seal the records. So that's where you file it, as district court.
Great, thanks. And then, so we have one more question in the chat and two in the Q&A. We'll do those, and then we'll have to close for today. I know this is a lot of information. And so, is the civil petition that's filed in the district court considered a public record that must be disclosed? And will that civil petition disclose what is filed in that petition?
So non-conviction expungement petitions are filed under seal, so they're not accessible to the public, like as of filing them. Anything else, they are public record until an expungement has been granted. So an order granting an expungement includes an order to expunge the expungement proceeding itself. So once it's been granted, there won't be any record of, that you can access online of the expungement itself or the underlying case that's been expunged.
Okay, great. And then are the rules and forms written in easy language or more legal language?
I'm not sure I'm a good one to answer that, because I mean, I feel like they're fairly straightforward, but I've also been doing this for a while. And so I might think it's easy enough to understand, but I think it depends on who's reading it and their level of, I think for some people who are not lawyers, they could understand it, but I think some things are hard to understand. So I think, if there's guidelines from, like the district courts that can explain this stuff, I think it's going to be a lot easier to understand.
Thanks. And finally, how does expungement connect to pardon requests? Are the criteria similar?
They would be very different. I have not done pardons, but a pardon is something that basically just completely nullifies a conviction entirely. It's going to have a different effect on restoration of rights. It's going to make it so the conviction actually didn't happen. Whereas expungement has to do with records and access to records. Yeah. And if there's any further questions that we didn't get to, please feel free to call me or email me. I'm absolutely happy to answer questions.
Awesome. Thanks so much. And thank you, everyone who attended. And I'd be very remiss if I didn't thank Juan Abeta, who is working with the Access to Justice Commission, helping us organize these webinars. So thank you also, Juan, for all of your help. And we will, I will send out the materials from today right after this session, and be on the lookout for the recording link as well. It'll probably be about a week or so before we get that up on our YouTube channel and the link available to everyone, but I will get that out as soon as I have it. And just thank you again so much, Kate, for being here with us today.
Thanks for having me.